I welcome everyone to this public hearing into the Territory Coordinator Bill 2025. I welcome via video conference to give evidence to the committee from the Arid Land Environment Centre, Alex Vaughan, Policy Advocacy Coordinator, and Hannah Eichen, Frack Free Campaign Coordinator. Thank you for coming before the committee. We appreciate you taking the time to speak to the committee and look forward to hearing from you today. I'd like to acknowledge my fellow committee members. I am Andrew Mackay, the member for Goyder. We have the member for Gwoja, Chansey Paech, the member for Drysdale, Mr. Clinton Howe, the member for Johnston, Justine Davis, and joining us via telecommunication is the member for Wanguri, Carlson. This is a formal proceeding of the committee, and the protection of parliamentary privilege and the obligation not to mislead the committee apply. This is a public hearing and is being webcast through the Assembly's website. A transcript will be made for use of the committee and may be put on the committee's website. If at any time during the hearing you are concerned that what you say should not be made public, you may ask the committee to go into a closed session and take your evidence in private. Can you please each state your name and capacity in which you are appearing?
My name's Hannah. I'm part of ALEC's policy and advocacy team, and I specifically focus on onshore gas expansion in the NT.
And hello, my name is Alex. I'm also part of the policy and advocacy team with more focus on water, mining, biodiversity.
Would you like to make an opening statement?
Yes, we've prepared a short opening statement and very keen for questions. So Alex strongly opposes the Territory Coordinator Bill. The Territory Coordinator we consider to be extreme legislation that will give unprecedented, far-reaching and discretionary powers to an unelected bureaucrat, the Territory Coordinator, as well as the Minister for the Territory Coordinator, currently proposed to be the Chief Minister, to majorly change the powers and function of government here in the Northern Territory. ALEC has grave concerns in general with the legislation, but also explicitly the primary principle, step-in powers, exemption powers, and suppression of scrutiny, removal of accountability, and major limitations on community rights around the development and assessment of major projects, including the particular rights of traditional owners whose land is affected by the development. We consider this to be authoritarian legislation that lacks safeguards and oversight mechanisms, particularly in a jurisdiction like the Northern Territory, where there is only one House of Parliament and the elected government has largely unconditional control and power. The proposed legislation disproportionately benefits and is tailored to the interests of big business. In this context, the bill gives an excessive concentration of power to two people, which leaves the Northern Territory more vulnerable to state capture, mismanagement, and corruption. The Northern Territory proposal is a radical departure from good governance principles, is a dangerous precedent to establish in the Northern Territory, and leads us on a journey of chaos and dysfunction around planning, development, and environmental assessment. This is all occurring in the NT, which already has arguably Australia's weakest water laws, defunct climate laws, and no vegetation laws or biodiversity strategy altogether. Community rights and environmental protections are already largely unfit for purpose and scant across the Territory. The Territory Coordinator Bill, with its far-reaching step-in powers and exemption provisions, aims to fast-track gas fracking, big ag and cotton, as well as expedite new mines and potentially nuclear waste dumps. ALEC looks forward to your questions today, and yeah, we're keen to provide some case studies around the Singleton groundwater licence and fracking.
And I also just want to add my apologies for any shortcomings in our evidence. The short timing and major changes to the bill since the first consultation draft mean we're still getting our head around the full impacts of this bill. And I know other submissions have made similar comments, so I just want to reiterate that the timing of this process will severely limit the committee's capacity to fully understand and address community concerns like ours around this bill. But we'll do what we can.
Thank you. I'll open it up to questions from the committee.
Yep. I think just following on, Alex, from your comments around case studies and in particular around water in Central Australia, I just want to pose two questions, of which I think will probably be able to be amalgamated. But what impact could the bill have on Central Australia's already fragile water resources? And then in addition to that, the second part is, could this bill make it easier for large-scale water extraction projects like the Singleton station to proceed without proper safeguards?
Great. Thank you for that. Well, definitely this can have dire and significant impacts to water allocations across the Northern Territory within water allocation plans, which should note have been gutted already by changes that have been made in this term of Parliament already, as well as outside of existing water allocation planning areas under the water allocation planning framework. We already have scant protections, and I think just focusing on Singleton as a useful case study to understand the ramifications to other areas, which is in the Western Devonport Water Allocation Plan area. People that may not be aware, that's about 3 hours north of Mbantua Alice Springs, and where the bore field is proposed is about 30 kilometres to the west of 𝚂𝚒𝚗𝚗𝚎 community. Singleton Station is unique. It's in its scale and it's nationally significant. It is what we understand to be the largest groundwater freshwater licence in the country, where Fortune Agribusiness was awarded in 2021 a 40 billion litre groundwater licence. And for scale, that is all the water that is used in Darwin every year, and that is to one proponent in the Northern Territory, and that water, as we know, is for free. They do not pay for that water. The scale of that extraction is over 1 trillion litres over the 30-year licence, which is equal to 2 times all the groundwater in Sydney Harbour. 1 trillion litres, hard to capture, but we're talking about hugely expansive impacts here. This is a shallow groundwater region where just a few metres below the surface is the groundwater table, and this project proposes to lower the groundwater table by 50 metres, 50, which threatens to damage and destroy a 50-kilometre stretch of groundwater-dependent habitat, threaten up to 40 sacred sites, as well as bring up to 40,000 tonnes of salts to the surface every year. This evidence is all from the department and the proponents all work, just to ensure this is probably a conservative number in terms of the impacts could be greater than this. And on top of that, there's still extreme levels of uncertainty that exist with this project. What are the impacts explicitly to certain cultural sites, groundwater-dependent ecosystems, as well as the salinity impacts? A government report already states that it could have far-reaching implications for the land use in that region in the medium to long term already. The Singleton project is useful because it is currently undergoing the environmental assessment process. It is the first agricultural project in NT history to get the highest level of uncertainty assessment. This is not because of lawfare. This is not because of activist groups. It's because of the disproportionate and extreme impacts that are proposed from this development, and the huge amounts of uncertainty that is making this really go through a rigorous process of assessment and scrutiny. This bill, with the step-in powers, could grant the Territory Coordinator to make the decision instead of the Northern Territory Environment Protection Authority, or potentially exemption powers could be used to exempt certain aspects of legislation from this project altogether. So around this project, there's huge and ongoing resistance to this development, but the reasons for that are based in the severity of impacts and the uncertainty that exists. And this is a nationally significant scale of water extraction in this region, handing over up to 1 trillion litres of groundwater for free to the proponent. And this could be represented elsewhere. If we look at the Tea Tree Basin, up at the Georgina-Wieso Basin and other areas where there's already scant protections for our water, and then this legislation kind of further promotes sidestepping scrutiny and accountability measures, and obviously the concerns of communities affected by this development.
Thank you, and thank you both for appearing today. Just following on from that, you said in your opening statement you characterised this bill as bringing potentially chaos and dysfunction to the Northern Territory. You talked about it being a dangerous precedent. I'm just interested in your comments on how you foresee this bill affecting our overall governance here in the Northern Territory, particularly in terms of transparency, accountability and public trust.
Do you want me to give an example? So I think that some of the issues that we have, while this bill's stated purpose of it is to streamline our regulatory processes, I think it actually opens up a lot more uncertainty, because the level of discretion that the Territory Coordinator and Chief Minister will have, there's a lot of questions around that, how that will interact with existing laws, both territory laws and of course federal laws that have precedent over territory laws. An example of that would be how it might interact with the Native Title Act or the Land Rights Act. I can foresee, for example, in the development of shale gas in the Beetaloo Basin region near Elliott, there is currently a process of negotiation required for the sale of appraisal gas. There's a number of companies wanting to sell what's called appraisal gas, so gas where they don't yet have a production license. And to enable that sale, laws were passed a couple of years ago that ensured that if they are selling gas, even if they don't do it under a production license, they would have to go and negotiate with native title holders and ensure that the same processes apply as they would under a full production license. And this is so to ensure that this Petroleum Act, NT Act, is in line with the Native Title Act. And what I can see as a possibility happening through the Territory Coordinator is that relevant laws, for example, the provisions under the Petroleum Act that say if you are going to sell gas, you have to first go through appropriate native title processes, could be overridden. And this would lead to both a loss of rights for native title holders who have the right to negotiate over royalties and over protections that they might want for their land. Also, it leads to the possibility, sorry, I don't know what Teams is doing there. It also leads to possibility that that there could be legal challenges, and it actually for the proponent, it's greater uncertainty because they're not sure if they can get away with doing things this way or not. Of course, for native title holders, it's very confusing, and it also places an unfair burden on them to prove in court that they have the right under native title to negotiate with such developments. And it's just all backwards. And I think that could really lead to, an erosion of trust in NT governance and legal proceedings, mean that the NT government winds up in court unnecessarily and actually increase the likelihood of that happening, not decrease, and generally create regulatory chaos. And I think what we need to be doing is instead making really clear processes that everyone has to follow, and investing in our Environment Department and creating the legal frameworks that mean that they can actually appropriately assess applications and their environmental impacts and enforce any problems that might happen. Perhaps another example that I'm concerned about, and I note that some of these examples have also been raised by the Northern Land Council and the Central Land Council, who facilitate these processes and know more about them than me. I'm not a lawyer, but so for more detail on that one, I suggest that you read the Northern Land Council's submission. Another thing that we're concerned about is around the prosecution of any breaches. So at the moment, for example, as a result of many, many years of community concern around the impacts of shale gas fracking in the NT, we have more of a solid process of approvals basically required to analyse the impacts and assess the impacts, environmental impacts that those projects would have. But and part of that is that if something goes wrong, the environmental management plan says, okay, you want to drill and frack 10 wells over here. These are the things that you have to do. That you say, I will take these measures to ensure that that this is safe. For example, around the storage of wastewater that is toxic, around weed management, around bushfire risk, all of these things. And if you don't meet the terms of that contract, you can be prosecuted by the NT EPA. And within the Territory Coordinator, my read is that this could, if the Territory Coordinator chooses to remove this process, say this company doesn't need to go through it because we want to see this project get up, both the initial scrutiny isn't there and the capacity to enforce for the government to, you know, prosecute a company, a proponent who does damage is not there. So this could lead to a lot of unknown outcomes that are really dangerous.
And just following on from that, given what you've described as a lot of potential uncertainty, do you think that that could actually contribute to delays in decision making rather than speeding things up?
If I was a company wanting to undergo a major project in the NT and I saw these laws and I got told, okay, Territory Coordinator says that your project is a priority, so just don't bother with anything, I would be thinking, what about if I trigger the EPBC Act federally? What about if I get taken to court by traditional owners? What about if something goes wrong and I find that in fact these laws were, you know, were unconstitutional or in conflict with other parts of NT laws? And I think that would make it really hard for a proponent to make informed decisions and proceed, knowing that, investors, etc., would be wondering, is this a safe thing to go ahead with? What am I doing? And I think that investor uncertainty could plausibly lead to companies taking a longer time to go through the processes.
Thank you.
Any further questions?
Thank you. I just following on from the member for Johnston's questions. Obviously, the current government have removed the merits review, which would then only now allow judicial review if being challenged. So we see that as a mechanism which won't speed up development. In fact, will probably prolong it even more before the judiciary. Alex, I just wanted to go to your point around the water concerns around allocations and approvals being granted. And I'm just wondering if you could provide some comment on, I guess, the landscape in the process or the concern in the community around you have the Northern Territory Environment Minister who's revoked the water allocation plan in the Davenport Ranges. What level of concern do you think that provides for proponents looking to do a project with their social licence when you've got a Territory Controller who's awarding water and could be in contravention of the water allocation? Where's the level of transparency, accountability and liability? I guess that's probably a major concern for your membership group, is it not?
Definitely. Using water in the Western Davenport Water Allocation Plan as an example is really useful. We saw, I would say, that the Northern Territory government is not trusted on water, particularly water allocation planning. The Western Davenport Water Advisory Committee was stood down without any consultation. This water allocation plan was revoked without any consultation, and a new plan was put forward without any consultation that increased water allocations in the region by around 30%. This has been an extremely contentious an ongoing issue in the region, but it's predominantly been with most stakeholders against the Northern Territory government's agenda, which is to suppress scrutiny and ignore the varied decisions, but that fundamentally too much water is being allocated in this region. And that water plan in and of itself, Singleton gets about half the allocation, but it's now double that. So the amount of habitat that is at risk of being damaged and destroyed is 100 kilometres in that region. The government does not have good relationships in that region. It's not trusted around water resources. And this further erosion of scrutiny assessment coming through this bill, and obviously water resources and water licences are fundamental to major projects from mining, fracking, big ag projects, cotton, as well as potentially, other vehicles. We have, very big issues around the approach taken here, which is that, affected communities, experts are being explicitly excluded already around water. And we're seeing the Territory Coordinator creates opportunities for the merits of people's concerns being further ignored and undermined again. And Singleton and the Western Davs is a great case study. But obviously, Mataranka, Georgina Wieso, and the Tea Tree Basins all have huge question marks over them. And we know that water is intrinsic to our way of life in the Northern Territory, in the arid land, across the arid lands. We are basically 100% dependent on groundwater. It shapes where people live, storylines and culture, as well as environmental values. and these processes within, in complement with the Territory Coordinator Bill and outside of it, create a very scary proposition around the future management of water resources in general.
Thank you. And you've made reference to sacred sites, and I do acknowledge in the legislation there is the provision around considering and excluding sacred sites, but we know that heritage is listed in there. I guess my question to you is around water and the important role that water plays with sacred sites, in terms of sacred sites are not necessarily just objects, they are living trees, shrubs and soakages. You were mentioning that this would potentially have the risk for that legislation, whether it's saying it's included or not, would have an unintended consequence on that if you are extracting large amounts of water that have been approved by a territory coordinator, would unintentionally destroy Aboriginal sacred sites because of the reduction of the water table.
From anthropological work that the Central Land Council has done to do with that Singleton project, we understand there's up to 40 sacred sites that may be impacted as a result of this level of groundwater extraction. And yes, sacred sites can't be legally damaged, but we have significant concerns around the slow erosion and damaging and potential destruction that can happen in situations where in situ water is gradually removed as that groundwater table is lowered by over 50 metres, up to 50 metres, sorry.
And I'd also like to add on that while the Sacred Sites Act isn't currently scheduled for as part of the Territory Coordinator Bill, we're really concerned that in the first draft of the bill, it explicitly said that sacred sites and heritage would not be impacted. Our understanding is that later government can simply create regulations without going through Parliament that would add the Sacred Sites Act into the schedule at a future date, which means that legislation like sacred sites could still be interfered with by the Territory Coordinator. And we think that there needs to, one of the things that should be done to this bill is that they should reintroduce protection of the Sacred Sites Act and Heritage Act to exclude them specifically from being interfered with by the Territory Coordinator.
So that should be prescribed in the legislation that they are exclusion zones. And would you support the expansion of that we heard earlier from top end coasts around areas should be excluded, should be enshrined in the legislation around the particular coastal marine areas being no-go zones as well? So you think that it's better to have it enshrined in the legislation rather than be told the goodwill of government won't be to touch those?
I guess that really gets to the heart of the problem with this bill, is that there's really the bulk of the decision making is, at the heart of the government, and we are reliant on hoping that whoever makes that decision chooses to make the right one. And I think that lack of clarity is really what has people alarmed. So yes, the more things that could be outlined as certain things that couldn't be impacted, the better. Another example might be, if they're going to declare one of these territory development areas, that shouldn't happen on Aboriginal land, that shouldn't happen on national parks, on areas that have already been identified as places that should be protected, and that if it was going to happen, for example, on Aboriginal land, that there needs to be a process where the Aboriginal landholders, have the right to say yes or no to the application of a territory development area.
Just quickly, Alex, just to follow up on some of your points, you mentioned the government avoiding scrutiny, especially with regards to the legislation. I'd just like your thoughts on the fact we're here, we've raised this committee, we have a parliament, we're broadcasting this to the NT, and to listen to any ideas you have on how we can improve it. Do you not think this is potentially some of the strongest scrutiny that's been able to be done on legislation in the Parliament in some time?
3-day turnaround.
ALEC welcomes the Legislative Scrutiny Committee, but we've also engaged in this process from the start. We've provided 3 submissions now to date on this bill, and all we've seen is this legislation, despite overwhelming responses against it, and the far-reaching and wide and discretionary powers and unprecedented powers have been given, we're seeing largely no changes be made and only the powers become even more broader, less transparency and more vague. We haven't seen safeguards be introduced. So from the evidence that we've seen in the direction that this bill has been proposed, in addition to the consultation largely being over the summer Christmas window, there was an opportunity for huge amounts of stakeholders to participate in this process, and these bills give unprecedented power, further remove merits rights, and it's only judicial review. But it's also, we've heard from the interim territory coordinator himself, as well as the Environment Minister, that there's big business and industry really supports this bill and legislation. But when questioned on what projects currently have been held up, neither has been able to list a single project that has been affected and held up by our current, regulatory reform system. The Environment Minister has used Singleton as an example of lawfare, but that's just not true.
Yeah.
It hasn't disrupted the process. They're still trying to get their environmental.
I suppose my question goes to, regardless of the decisions of the minister or how the government's responded, how would you like to see, how can we go any beyond, like even what we're doing right now, for anyone in the NT to listen to your organisation's views? How could we make that any better than what we've done today? Yes, please.
I can think of a few things. As Al said, I think that the Scrutiny Committee is good. It was a very short time frame, which means that I think a lot of people have not been able to get their heads fully around the bill. And it's also very difficult. We're literally gaming out what might be able to happen with this bill, but it's much more difficult to scrutinise decision-making in the abstract of what could they possibly do with the Territory Coordinator than what I'm used to, which is a specific decision about a specific project, being able to look through the documents and make an analysis, I guess, of what the risks are and whether or not that's a good decision. So while it is positive to have this Scrutiny Committee, previous rounds of submissions and consultation have led to the release of just like a summary that no one really understood. They were done very quickly. They were done over summer. People are quite fatigued by this process. I tried to get more people to engage with this consultation process, and I heard from a lot of people, we already did a submission. We already turned up in person. They just made the legislation worse. Why should we bother? What can be achieved out of this? And while I did try and convince them that things could be achieved out of this, I think that this is a real problem, a lack of faith in the intent of government in engaging with scrutiny. And so I think that things that could be done to improve that are to have this process earlier in the piece before that, when we don't have a sense that that it's a done deal effectively, and also to give people the time. And ideally, like a bill this broad is very, very hard to actually understand the full implications of. I think it's better governance to break things down into more specific outlines of government powers, so that we can really understand the implications and have informed input.
Ideally, I think this is, the reform, this is like unconditional transformation of the powers and tools of government. And this would have to be a multi-year process, and actually talking to affected communities. And as Hannah just said, hopefully there'll be targeted engagement, like we've seen more in South Australia, around actually what the aspiration is of the government introducing this legislation, rather than unconditionally vague legislation around where and how the powers can be used. And for the Territory Coordinator, who in our briefing didn't even know what an environmental impact assessment was, be responsible for the administration of potentially 32 different pieces of legislation. And as Hannah pointed out, that just through the regulations, we understand that, a whole other tranche of bills could be introduced, whether that's around nuclear waste or otherwise. It's just not possible for someone to be able to be across all that legislation. One piece of legislation is difficult enough, and then to put the onus on community stakeholders, affected communities, and other non-government organisations to engage with this over a summer period. I don't think that is supporting a transparent or rigorous process, but it is clear by the overwhelming responses, even to date, over 250 submissions with 1 week's notice, demonstrates the concern that people have around this project and the process in which around the territory coordinate proposal, but also the process that underlines it.
We'll just one more question from the member for Johnston, I think, just in the interest of time and fairness, and then say what else.
So thank you. Following on from that, and thank you for those suggestions for how we can improve the process of scrutiny into the future. Given where we are now with this bill, we've had a suggestion from the consultation, the submissions that were put into the previous consultation process. They were made public, at least how many were for and how many were against, so people could see that. I note that you made reference to this, and also in your submission that the interim Territory Coordinator had said that extractive industries have been lobbying the government strongly in favour, and we note that some of the changes to the two versions of the bill which you've outlined are very concerning in terms of potentially benefiting those industries. So in terms of bringing more transparency to that lobbying and to what happened with that initial consultation process, I just wonder whether quickly you had any thoughts, not so much into the long-term future, but if there's anything that we could do now to try and give people the sense that the government is committed to actually being open to what people are concerned about.
I suppose some things that I think could be done. I mean, it would be good for those original submissions to be public in the way the Scrutiny Committee ones are, so that we actually have the content, particularly when, you know, they're being summarised and we're being told. It's quite hard to know who the people are who's saying what, and it gives you a bit better picture of what the balance of opinion is on this. And also, if industry has been strongly lobbying for this bill, we would like to know who specifically and what they have been saying and how they're communicating this with government. I guess this is more a question more broadly around, like, we go through this transparent process of consultation, but industry have a different form of access to government, and so we often don't know. I look through the Scrutiny Committee submissions, admittedly, like just the day after they were, that there might have been more that were uploaded, but at the time, I mean, things like the Pastoral Land Board just said it's good, and that doesn't really give us a clear sense of, have they met with the government and said put this, this and this in, you know, like, so it would be, if there are ways in which they're feeding into the process outside of the formal submission process, whether it's meeting with ministers or whatever it is, that should also be transparent and made public.
Thank you.
Any other thoughts, Al?
I think that's good.
Well, on behalf of the committee, I'd like to thank you for taking the time to meet with us and putting in the submission. And I do acknowledge the short turnaround and pressure it would have put on your organisation, but thank you. And thank you for taking the time.
Thanks, guys.
Thank you.
Likewise, thanks for having us.
The committee will now take a short break until 12:30, where we will have the City of Palmerston joining us.
Oh, City of Palmerston. Hey.